Good evening, Narendra sir.
Good evening, Dr. Gitendra.
How are you, sir? Because I am fine, sir. For the benefit of the viewer, I will introduce sir. Dr. Narendra Gajjar sir is from Navsari, and he is practicing for last 40 years as an obstetrician. So he is one of the senior most obstetrician of Gujarat. He was past president of our SOGOG, that is State Organization of Obstetrician and Gynecologists of Gujarat. He is expert in vaginal surgery, and he has demonstrated at multiple places different difficult kind of all vaginal surgeries. He is efficiently managing high risk pregnancy cases in one of the remote areas, we can say, where the facilities are not available up to the mark. So, sir, welcome to this web meeting.
Thank you, Dr. Gitendra, for nice words. And let me tell you that Dr. Gitendra Sharma is a stalwart in the field of medical legal. He is a medical legal expert, he is a gynecologist, and he has written a book on consent. So he knows our problems very efficiently, and he has guided many of our colleagues in difficult situations.
Sir, you wanted to ask some medical legal question to me.
Yes, Dr. Gitendra. Suppose a FIR is to be filed against a doctor.
Yes, sir.
Under what circumstances FIR can be filed? And suppose it has happened at many places, unnecessary FIR is on file. So what are the remedies? Please guide us.
Okay. Sir, basically, the question is whether FIR against doctor can be filed directly by the police officer or not under different section of IPC. And second, that suppose if FIR is filed, then what is the remedy for us? Okay. So, sir, we all know that in 2005, on 5th August 2005, a decision, very nice decision came from Supreme Court. All the three judges, Justice Lahoti, Justice Mathur, and Justice Balasubramaniam, all three gave a very nice judgment in a case from Punjab. That was the case of Jacob Matthews versus State of Punjab. In that case, an aged person of around 72 years got admitted at 11 o'clock in the night for the treatment of terminal cancer, and he was feeling breathless. So, due to non-availability of oxygen cylinder in hospital, he actually succumbed. And later on, a case was filed by his son that this should amount to a criminal negligence, and under 304 section subsection A complaint was filed against doctor. Now that case was challenged, and in that case, the Supreme Court very nicely gave the guidelines, and they have given 3 observations and they have given 3 guidelines. Very important to know, and we always tell our colleague to keep 1 copy of this judgment ready always in their consulting room, so that if anything happens or any wrong complaint is filed by some police officer due to ignorance of this case, then we can at least show them that this is the judgment of Supreme Court which every police officer is supposed to follow. So in this judgment, it was a very nice judgment, and Supreme Court, all 3 judges have mentioned that we have noticed here in above that nowadays criminal cases against doctors means physicians and surgeons both, are on rise. So many cases are filed, and most of the cases are filed either by the police constable or by the relatives of the patient who do not have knowledge what is medical negligence. And once the case is filed, the doctor has to suffer a lot, has to go to seek the bail. Sometimes they may get bail, sometimes they may not get bail. But the amount of harassment and I can say the harassment to the doctor is irreparable. So he may be exonerated at the end of the case, but whatever kind of embarrassment and harassment he has suffered, there it cannot be compensated by any kind of compensation. So what they said, that doctors are in a noble profession and there is a need to protect the doctor against such kind of embarrassment or harassment, and there is a need that we should develop some guidelines to protect doctor, because they are into a noble profession and they are doing good to the society. If we will not protect them, then under the fear of law, no doctor will be able to exert his level best, and no doctor will accept serious cases if we will not protect them. So there is a need to protect doctor, and to protect the doctor, MCI means Medical Council of India, in association with central government, or State Medical Council in association with state government, should come out with such guidelines which will protect doctor against such wrongful prosecutions. So that was the judgment given by Supreme Court, 3-judge bench. And they said that since the guideline is been framed by any association or by government, we are giving guidelines which are to be followed. And in this case, Supreme Court has given 3 guidelines. The first guideline said that no police officer can file an FIR only on private complaint which is filed by the relatives of the patient, unless it is associated with some opinion, unbiased opinion of doctor of similar stature. So suppose you are a gynecologist, then if some other gynecologist would have opined against you that you are negligent, only then an FIR can be filed against you, and otherwise FIR cannot be filed. And second thing, if there is no such expert opinion or unbiased opinion associated with the complaint, then it is a duty of the police officer to ask for an unbiased opinion, preferably from the government hospital, who are competent and who are having proper knowledge in their particular field from which the doctor is, against whom complaint is filed. So investigating officer should ask an independent opinion from the body of the from the committee. A committee is to be formed, and the unbiased independent opinion, preferably from the government hospital, should be demanded. And if that opinion comes against the doctor, and if that opinion says that doctor is negligent, only then an FIR can be filed against doctor. Otherwise, FIR cannot be filed. Now, the third thing that the guideline was that doctor cannot be arrested even if FIR is filed against doctor, but doctor cannot be arrested in a normal routine manner. Doctor can only be arrested if the police officer has reason to believe that if I will not arrest the doctor, then doctor will flee away or will be eloped. Only then he can arrest. Otherwise, in normal circumstances, police officer cannot arrest doctor in a normal routine manner. So these were the guidelines given to police officer, and immediately after that, a few years later, in cases of Markande, this M. D'Souza versus Muhammad Ishfaq's case, Justice Markande Kadzu in 2009 gave decision that if any police officer do not follow these guidelines, then he can be punished for the same. So it is mandatory to follow the guidelines of Supreme Court. And the second part of your question is that ignoring the guidelines of Supreme Court, if some FIR is filed by some police officer against doctor, then that FIR can directly be quashed by going in High Court. So we can go in High Court directly under quashing, and we can quash that FIR against ourselves because the proper procedure is not being followed in filing the FIR. So hope it is clear, sir.
Yes, thank you, Dr. Gitendra. You have very nicely cleared the situation. Let me say you that you are really a very good medical legal expert, and it will be a matter of proud for us to elect you as a Vice President Foxy because none other can represent our problems at national level.
Thank you,
Thank you,
sir. Thank you, sir.